Do you have any idea what their defense is going to be, given the fact that the judge has basically taken away their defense?
Am I the only person in the world talking about attacking the timeline,
Do you have any idea what their defense is going to be, given the fact that the judge has basically taken away their defense?
Like, am I in crazy?
Challenge the timeline of the murders.
Talking about attacking the timeline.
What's the strategy today? Winning.
Whose motherfucking hair is that?
What's the strategy today? Winning.
The consensus has been challenge the timeline of the murders. Challenge the timeline of the murders.
Sponges. Hello. How's everybody doing? Welcome to R&M Productions. I'm so excited to be here, everybody. How many people we got here? What day is it today? It's today Tuesday. I almost said happy Tuesday, but I have trauma now from saying it was Friday last Tuesday. So how's everybody doing? Who we got? We got Joanna. We got Judy. We got another Judy. Bless Rick Allen's defense team. Bless all of you for keeping this case public. Praying for justice, free Rick Allen. Yes. Amen. Amen. Speaking of amen, there is a man who needs to get up here and talk to us about what the heck Glossip means. Hello, Michael.
Hey there.
How you doing?
I'm a little bit worn out, but I'm happy to see Glossip enter the chat.
It's about time. Would you like to read through it with me?
No, you go ahead and read. I'm on my phone, so I can't see, but feel free to read it. And then, I don't want to stay. You all got a bunch of things to say, but I also, maybe I can explain Glossip a little bit for folks.
I would love that. It's pretty short, so I'm going to read through it. And by the way, Andy K says, I'm trying to book him for my show tomorrow, so I will put my people in touch with her people to get in touch with your people. And you and Andy can talk about Glossip tomorrow.
I ain't got no people.
He says, I am the people. All right, here we go. We're going to read through this. Let's see. And this is coming to us courtesy of Miss Kara Weinicke's Twitter. Between Michael and Kara, we've got all the breaking news updates we need from our trusted attorneys. Y'all can touch each other's people, can get in touch. All right, here we go. Defendant's motion to reconsider denial of motion to correct error. Comes now the defendant, Richard Allen, by counsel, and files his motion to reconsider denial of motion to correct error. For the reasons that follow, in light of Glossip v. Oklahoma, as revised February 25th, 2025, Mr. Allen requests the court reconsider its denial of that motion and either vacate Mr. Allen's convictions or set the motion for a hearing. At trial, the state argued that Brad Weber came home from work in his Ford Ecoline van on February 13th, 2017, at approximately 2:30 p.m. The state also argued that Liberty German's cell phone did not move after 2:32 p.m. on February 13th, 2017. The state further introduced a confession written by Dr. Monica Walla, that Richard Allen told her on February 13th, 2017, he kidnapped Abigail Williams and Liberty German on the south side of the Monon High Bridge and was on the south side of Deer Creek with the girls, intending on raping them when he saw a van and became scared. Richard Allen allegedly told Dr. Walla that after he saw the van, he forced Abigail Williams and Liberty German to cross Deer Creek to the north side, where he ultimately killed them. As set out in his motion, the state knew or should have known that Brad Weber's trial testimony that he returned home in his van about 2:30 p.m. on February 13th, 2017, before Liberty German's phone permanently stopped moving at 2:32 p.m. was false. See motion to correct error 8 through 13 and the attached exhibits. In fact, Mr. Weber arrived on his private drive after 2:44 p.m., well after Liberty German's phone stopped moving on the north side of Deer Creek at 2:32 p.m. Additionally, Exhibit 3E to the motion to correct error, as an FBI subject information sheet for Mr. Weber, shows that Mr. Weber's cell phone first started pinging at his family's home at 2:50 p.m. that day, also well after Liberty German's phone stopped moving at 2:32 p.m. The pinging of Brad Weber's phone is consistent with his arrival after 2:42 p.m. and not consistent with an arrival time of 2:30 p.m. In light of the security video and the FBI subject information sheet for Brad Weber, the state's narrative that Mr. Weber's van interrupted Mr. Allen before 2:32 p.m. is impossible, and the state knew it. In Glossip v. Oklahoma, decided last month, the United States Supreme Court says, the Oklahoma Court of Criminal Appeals also held that Snead's testimony was, quote, not clearly false, end quote, because Snead was, quote, more than likely in denial of his mental health disorders, end quote. It is not apparent why the OCCA thought that Snead was in denial, nor why such denial could have caused Snead to believe that he had never seen a psychiatrist, when in fact he had. Even supposing it did, however, Snead's beliefs are beside the point. What matters is that his testimony was false, and a prosecutor knowingly let it stand nonetheless. Is it Napue? Napue. We'll clear that up in a minute. It is established that Napue.
Napue.
Napue?
Like Napue, like Baba Louie.
Napue Baba Louie. Got it. Let it stand nonetheless. Napue. It is established that a conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. Glossip v. Oklahoma. Emphasis added. Regardless of whether Mr. Weber thought he arrived home at about 2:30 p.m., the state knew or should have known Mr. Weber's testimony was false and knowingly let it stand. The state's refusal to correct Mr. Weber's testimony and letting his false testimony stand violated Mr. Allen's due process right to a fair trial, as stated in Napue and argued by Mr. Allen in his motion to correct error. Because the state explicitly relied on Mr. Weber's false testimony to obtain Mr. Allen's convictions, Mr. Allen is entitled to a new trial. A new trial is warranted so long as the false testimony may have had an effect on the outcome of the trial, Napue. That is, if it in any reasonable likelihood could have affected the judgment of the jury. Giglio? I know that's an important one, but I don't know how to say it, Michael.
I think most people say Giglio, but of Course, if you're Italian, it's Giulio.
Giglio versus the United States. Got it. And here's a footnote. The full 82 pages of the Supreme Court's opinions in Glossip are available at this link. Michael, is this going to redirect us to your YouTube page? Don't lie.
No, it's going to redirect them to the Supreme Court's website.
I gotcha. Got it.
The Supreme Court, a few clicks.
They could use a few clicks. My gosh. All right. In light of Glossip's unambiguous reaffirmation of Napue, the court should reconsider its denial of Mr. Allen's motion and either vacate his conviction or set the motion for a MFing hearing. Conclusion. For the foregoing reasons, Mr. Allen respectfully requests that the court reconsider its denial of his verified motion to correct error and either vacate Mr. Allen's convictions or set the motion for an MF hearing and for all other relief just and proper in the premises. Jennifer Auger. Put a 1 in the chat for Jennifer Auger. Nice to see Jen. Beautiful, Michael. What do you think?
Yeah, I think, it's on the one hand, it's nothing the motion to correct error didn't say. On the other hand, the Supreme Court timely chiming in there are not many Napue cases from the Supreme Court, and for them to have come up with one right now was very helpful, because the thing about Napue that anyone who's gone out and done the research themselves, almost all the Napue cases, but only almost all, deal with situations where the prosecution knows that the witness is committing perjury. Lots and lots and lots of Napue cases on that. Terrible that there are, right? I mean, you shouldn't have prosecutors out there letting perjury happen that they know about. But Napue says more than that, and it doesn't come up often, but the Supreme Court in this case made it absolutely clear that whether the witness is lying or not doesn't matter. It's whether what the witness has to say is false. Now, I'm not talking about debatable things, really. You know, and what it means to know something. The example that came to my mind thinking about Glossip and how to use it in Rick's case is, imagine a prosecutor, imagine there's a robbery. And the prosecutor has a video of the robbery, but the prosecutor also has an eyewitness. And the eyewitness gets up there and identifies the defendant as the person who committed the robbery. Now, the prosecution has a video and has turned over the video in discovery. I mean, the defense has it too. But the video shows that somebody who looks a great deal like the defendant, but you can actually identify the person as not the defendant, committed the robbery in the video. The prosecutor, regardless of what the defense does, doesn't get to have the eyewitness ID the defendant as the perpetrator of the robbery if they've got the video showing it's not.
That makes sense. That feels reasonable.
Even if the witness is absolutely certain it was the defendant. And you know, when the motion to correct error was filed, there were a lot of people in places saying, "Oh, the defense had it. They could have used it and didn't for whatever reason. Too bad, so sad." And Napue's not about that. It doesn't matter what the defense.
Yeah, all of the responsibility and all of the onus is on the state, independent of what the defense did or didn't do or could have or couldn't have done. It has nothing to do with that. The state had an absolute obligation to either correct that testimony or not allow it to go forward, is kind of how I understand it. Like, regardless of the cool, like, it could be a circus of nonsense going around on the behalf of the defense, and that still has nothing to do with the responsibility of the state, according to Glossip, right? They have to correct that or stop it.
Glossip, yeah, right. And, you know, the Supreme Court has taken this obligation so seriously that the standard for prejudice is really low. There only has to be a possibility it might have affected the verdict.
Interesting. Well, somebody asked in the chat, and I can't find it now, but I will find it. But somebody asked a very astute question. Could the defense, probably not, because they'd have to contact the juror, right, and get a statement, but could the defense use a statement of a juror post-trial to support their argument that that false statement had an impact on the verdict, since we know that this juror was talking about the arrival of Brad Weber in the van and everything? Like, would it be worth quoting or including that, or is it not necessary?
Well, it would be nice if you could, but Evidence Rule 610 says you basically can't impeach jury verdicts. Notice anything a juror has to say about juror deliberations is inadmissible.
That's kind of annoying. I mean, I get it, but I don't like it.
The only thing they can testify about is external influences and presumably, I don't know. I think that they could. I think they could probably testify about, being physically threatened by other jurors. But they can't talk about the evidence of what they were thinking is inadmissible.
Right. That makes sense. What about nincompoop statements while interviewing juror? I suppose she means the Tweedles. Andy means the Tweedles. So nothing that came from that juror during that nincompoop interview would be helpful or admissible or anything because of that rule about impeaching jury decision or whatever.
No, but might have affected the verdict. I mean, look, lawyer, made, after the motion to correct error came out, made the really excellent point that Nick McClelland made a huge mistake in pinning down and putting out a story based on facts he couldn't prove. He didn't have to pin down, but he didn't have to do the whole that the girls were dead by 2:32 or very close to that. It could have been later. I mean, he can't prove the time, and
right.
He could have argued that, yeah, they're over there. The phone stops moving, and he could have fit it in with the confession a bit if he'd wanted to, but he didn't do that. And I mean, he told a very specific story, and really the way you analyze these sorts of claims is, I mean, look at the closing argument. And, if that's the state's theory and they convict, then the jury convicts, might the false evidence the crucial false evidence have affected the verdict? Well, yeah.
Yeah. Well, it's a good thing that they didn't include anything from that juror interview, because as Candy says, MS might strike the motion off the docket if they're caught quoting anything from it. So I guess that's a good thing. Oh, they're gonna copyright strike the CCS, Michael. Nick McClelland needed a story narrative for everyone to rinse and repeat in order to convict Rick Allen, in my opinion, and in True Crime Fangirl's opinion.
Well, he needed. So it's very interesting that, and again, people in the chat may have a better recollection than I do, and I'm happy to be corrected. But I thought in some of the summer hearings, or one of the summer hearings, I don't know whether it was Hirschman or somebody else, but they had the confession from Rick about the box cutter, and I thought they were moving in that direction. And maybe it was in a pleading of McClelland's and not in testimony, but I thought they were moving in that direction for a detail only the killer would know. And that didn't come up at trial.
It didn't, right?
And they moved after they got Weber in for an interview about the van in August. They moved to the van as the detail only the killer would know. Now, McClellan, in his response to the motion to correct error, is saying, "Oh, there's nothing new about this evidence, the video," which is good because that means he knew about it too. And so, having fessed up to knowing about it, and by the way, I think they were using security cam. So in the third-party hearing, again, people who are following more closely than I have the end of July and August 1st hearings. I think they tried to defeat the Keegan-Klein Dad's red Jeep thing in the third-party evidence with security camera footage from the same house. So they clearly knew about the existence of the security camera footage. And if they knew about it, then they knew. Now McClellan can argue, and at this point, if I were McClellan, I'd want the hearing. If he thinks he can prove if he thinks he can prove that the times are off on the security camera video, and as it fits in with the FBI subject information sheet and the pings at Brad Weber's family's house,
right?
If he can show those times are off, then he's in good shape. And I'm not saying he can't do that.
Sure.
I mean, that's why they have hearings. That's why they have hearings.
I am so in my opinion, and I hope I'm wrong, but I think that everyone here, including yourself, Michael, I think everyone will agree with this statement. Judge Gold has no interest or intention in opening this thing back up for a hearing. Is that a fair statement?
I have no idea. I do not know what motivates her. If she has presided over, let's just call it a $4 million trial. And if I wanted to preserve this trial, I'd have a hearing.
I would too.
I'd give McClellan. I would give McClellan an opportunity to shred this idea about the man.
Right. Once and for all, not let it linger. Just come out and squash it and put it to bed, and then your conviction's secure. You don't have to worry about it being an issue in any capacity. You certainly don't have to worry about, it being the fact that you've deprived them of a hearing, which she always does. But you would think that if they had a solid argument or rebuttal, or if he could back up any of the rebuttals that he's put forth in his motions without citing any case law, which he never does, you'd think that they'd want an opportunity to do that,
Yeah. Absolutely. Alternatively, I suppose you can say, we'll just let it go where it is. The Court of Appeals, the Indiana Court of Appeals, they're prosecution prone, so to speak. They affirm stuff that really shouldn't be affirmed, and so you can also roll the dice and take the chances that the Court of Appeals will come to the rescue.
Right. True. It's a good point. Oh, this is a good theory. Oh, by the way, Courtney Yellow Jacket is here. Michael, she's watching. She's in the chat. Hello, Courtney Yellow Jacket. So nice to see you. What a treat. We get a Courtney spotting, a sighting. Okay. So where is this theory?
All we need is another couple people and we'll have a full crank contingent.
I know. The full crank contingent. That's awesome. We have to add that to our we have a running list of crank vocabulary. We've got Glossip, we've got skull, what was it? Skullduggery and skull.
Well, there's skullduggery, but you changed it. You changed it more brilliantly to gullduggery.
Gullduggery. Yep. Thank you. I thought that was brilliant too, Michael. I appreciate you saying that. Is there a vehicle to correct the error without having a new trial, or do they go hand in hand?
Well, whether there's a new trial or not would be up to McClellan, but you have to vacate the convictions. In other words, Judge Gull would vacate the convictions, and McClellan would have to decide whether he's going to retry it.
Ugh, God, can you imagine? I mean, she'll never vacate this in a million years, but imagine if she did. You think Nicholas Mikletus would be up for like doing this again? He'd have somebody else do it, I think, is what he would do.
Well, I think a retrial would look a whole lot different.
Same. What's the quorum crank contingent? Well,
I'd say three's probably a quorum.
So we need one more. Love that. Well, Michael, what's your prediction as to what happens now?
Oh, denied without a hearing. I mean, this is talking to the appellate lawyers and the Court of Appeals, but it's getting it out there also that Rick's lawyers aren't making this stuff up. I mean, the Supreme Court. We're talking about the U.S. Supreme Court here. I mean, it's basically the only thing the state has now is to go after the facts. I mean, the law is pretty clear.
Right. Does the state have an opportunity to respond to this?
Well, I mean, for most motions it's funny. The rule, I forget which trial rule it is. They've got 15 days to respond. That doesn't mean the judge couldn't shorten it. And it doesn't mean they have to respond, but it's basically, if any, it's got to be within 15 days. Okay. On the other hand, we've got, today is the 11th. Notice this doesn't change the due date on the notice of appeal at all. So that's still due on the 20th.
Okay.
I'm pretty sure Stacey Oleon and Mark Lehman will file it before that. Mm-hmm. And Gull will lose jurisdiction when notice of completion of the clerk's record is filed. That's when the county clerk, or who knows, maybe it's Gull's own people, I don't know, basically lets the Court of Appeals know that all the documents filed in the case are ready. Not the transcript, just the documents.
Okay.
And at that point, Gull really can't do anything that would affect the judgment.
Yeah. And Chelsea asks.
And by the way, there's still. Go ahead. No, go ahead. What's the question?
Well, so Chelsea just asked, is there a reason that Ajay submitted this other than the fact that she is a legal queen? What would be the reason to submit this? Like instead of Baldwin, I think is what she's asking, or unless you're asking just in general, Chelsea.
Oh, I don't know. I mean, maybe it's like tag team wrestling. Andy was tired and he reached over and tagged Jennifer.
Okay, fair enough. But also just to restate, they're wanting a hearing, right? They're giving her another opportunity to rule again and differently before this is all said and done.
Yeah. Now, if she were to set that's an interesting question. I think she could vacate her denial of the motion to correct error. I think she could do that, and then set it for a hearing without action, and then set it for a hearing, and that would change the date on the notice of appeal. But a motion to reconsider doesn't do that.
Okay. So it depends on how.
And there is still another pending motion. And there is still another pending motion, and that is the motion for sanctions for the Brady for the discovery violation,
which also requests a new trial.
Yeah. Well, no. Yes. I mean, technically, it requests vacation of Rick's convictions. Again, whether there's a new trial is entirely up to McClellan.
Well, right. He's entitled to one, so the conviction should be vacated at the very least. Yeah.
So, Yeah, so now there are two things pending, and so yeah, I mean, the reason to get this on the record is set it up for the appellate. Look, if you don't play, you can't win. I mean, give Gall the opportunity to grant it. Why not?
That's a good point. If you don't play, you can't win. That's why I'm always cranking about I think it's better to be incessant than conservative when it comes to this, because if you don't ask, you're not going to get it. And I do think that Gull cares about the security or the whatever longevity of her conviction. You know what I mean? I think that she probably would want to ensure that it's not going to be overturned for some reason that she could have prevented. You know what I'm saying? I feel like she would not want that.
Yeah. Again, I don't know what her motivations are. If I mean, it's pretty hard. The motion to correct error itself, I would have set for a hearing for a couple of reasons. I would set I mean, if I were a judge and saw McClelland's response to the motion to correct error and the Reese Davis stuff, and then when the letters showed up, I mean, even if you're not going to vacate the convictions, I'd as a judge, I'd want to get the prosecutor and do a little, I'd have my 6-shooter out and having him dancing in front of the bench
to kind of explain himself. You mean, or to respond?
Yeah, absolutely.
Yeah.
I mean, absolutely. I mean, I just sat on a $4 million trial, bub. What are you doing holding on to letters?
Right. Yeah. Give a reason. And Tammy asks, so when they file the notice of appeal, does Gull get to just disregard any pending motions?
No. Again, she doesn't lose jurisdiction until the notice of completion of the court of the completion of the clerk's records filed. She could ignore it all, and the notice of completion of the clerk's record will get filed. She'll lose jurisdiction, and there's nothing more she can do or needs to do. So she could theoretically just ignore it all.
Right.
And at the same time, I don't know what the appellate lawyers would do. The appellate lawyers could, once it's in the Court of Appeals, ask the Court of Appeals, would you like send it back down, please, to Judge Gull to have a hearing on these matters, please?
Wow, I didn't know that was that was an option once it got to the appellate attorneys. Who would they ask that of? The appellate court?
They'd ask the Court of Appeals, because the Court of Appeals would have to,
send it back down.
Shit.
We got a Professor Craig expletive, everybody. Well, I'm going to keep looking. These questions are really good. Kat, this is a good question that I think I agree with you, but I don't know what the remedy or workaround would be. What about a retrial with Gull being the same as not getting a new trial? It's basically the same. I don't know. I can't really see her wanting to. I think she, in that instance, if this is vacated and Nick wants to bring it again to trial, I don't see Gull wanting to do it. I think she would recuse, but that's just, who knows? Who knows? Chelsea says, I think Gull's motivation is anything that will make the defense attorney sad. I think so. Best news heard all day. They set for a hearing. Not yet. We're hoping they do, though. Oh, we lost Michael. Maybe he'll be back. I just have no faith in Gull actually following law anymore in any way. Yeah, same. Hey, Debs in Space. I am totally late to this party. You are just on time. Gull has never had him explain himself. Why would she now? She won't. That's how I feel too. I mean, miracles happen, but hey, Cleveland Rocks, good to see you. Glad you caught alive. Hey, Nola Mama, I finally caught alive. You too. Welcome. Woohoo. Let's go. Hi, Mar. Sad it would be hard to prove that Ricky put more than one letter in one envelope. True. Did he make that? Did he say that he did? I mean, that's still, I mean, yeah, that would, yeah, they could just, oops. I don't think that completion of the court file will happen anytime soon. Hi, Classic Overthinker. I'm behind. Have you spoken about the battery being taken out in Ricky's letter? Have you spoken about the battery being taken out being in Reese's letter, though? That would be one of the letters that Nick says he doesn't have, I imagine, right? That's something that Reese would have claimed on case by case. Welcome back, mister.
I'm so sorry. I keep forgetting what a battery suck StreamYard is.
Yeah, it is. Among other things, it's a pain in the butt. Well, we're glad to have you back, Michael. Chelsea says, "Ooh, is there a deadline?"
Well,
for
having come back.
No,
yeah,
the
ahead. Deadline for the notice of appeals. So the motion to correct error was denied on the 18th of February, and the deadline for notice of appeal is 30 days later. So the deadline is the 20th, and I expect of March. And my guess is it'll be filed a few days before that.
Mm-hmm. Okay. Excellent. Did Ajay have to file an appearance for this?
I haven't looked at the CCF. I'm expecting she did file an appearance.
Let's look. Wouldn't that be a kick in the pants if Gull responds to one thing and it's just to be like, God, I could see her doing that. Even though she had no business removing them anyway, right? She's already gotten clapped for that once by the court of in the OA. Let's see. Whoops. I don't see one. Maybe she's hoping that Gull will be reasonable. Was this filed today? Yes, Cleveland Rocks. This was just filed this afternoon. I'm marking this in my calendar, says Chelsea. Thank you very much. Let's read it again. You want to read the whole thing again? Okay, Cleveland. We'll read it again in a minute. It's short. I brought that up earlier. A real prosecutor never would have risked a trial on this PCA. Reese said he did tell them about the battery in 2017. It must have been on the video that the video of the, yeah. Michael, did you catch Reese's newest case by case call in? I only caught part of it.
I did, and you know, I'm not sure who said what when, but my understanding is that if not in 2017, at least in one of his letters, Reese said something about a battery, and that was very telling because in the two letters that McClelland put in, he couldn't, quote, recover the third. There was no mention of a battery, which means there's nothing in anything the defense has ever said about a battery, and nothing. And so McClelland has seen some about a battery. He's not coming up with that. I don't know whether it's a video or the video from 2017 or letters. You know, the 2024 letters. I don't know where that came from. But you know, recall also though that in Cleveland, I think it was in the motion to correct error response, he also, you know, talked about Reese's account of what Ron Logan told him is not fitting the forensic evidence because, among other, leaving the battery out because it talked about and talked about burning the girls' clothes.
Yeah. Right. Miku, hello Ashley, welcome. Miku says, wait, does Osbrick agree that it is sus that the IDOC letters seem to have a Carroll County internal stamp, like Nick accepted the letters, or are all IDOC letters stamped in red?
Well, I'm not sure this answers the question. On one theory, the prosecution writ large, the office, got more letters. McClelland went to the DOC and got the records of what went out, but the only records that were there were what was sent legal mail. And even those are not always complete. But let's say they were complete, that there were 3 letters sent by legal mail doesn't mean that there weren't 4 more letters not sent by legal mail.
Right.
And again, I don't know what I don't know, what came in and who it went to. It's possible McClelland saw none of it. I don't know what it means to say we could only recover 2 of the letters. Recover from where? The trash bin? And it's, I think other people have pointed it out that one of the 2 letters, quote, recovered, mentions a note, an enclosed note written by Keegan Klein. And where's the note?
That's a good point. He's referencing it. Where the heck is it?
I guess it wasn't recovered.
From where? Recovered from where? That's a good question.
Well, I thought that was a very strange usage.
Yeah, like where the heck did you put them? Where were they that you needed to recover them from? Okay.
I mean, normally I'd say, well, I'd be saying, oh, I'm sorry. Yeah, we looked and we found 2 letters. We got the records from the DOC. It looks like there were 3 sent. We don't know where the 3rd one. We don't know what happened to the 3rd one.
Right. So this looks like, Miku, is this what you're talking about? This one here? Are you talking about a different letter or different copy? Felt like they started destroying all the stuff. The second goal denied that motion. I don't know if Nick's that dumb. He's either that dumb or is that smart. I think it's on the other one. Okay, let's see the other one. Why did and my other question is, why did Nick McClelland feel the need to redact all of this?
I'm sorry, what?
Why did Nick McClelland feel the need to redact all of that stuff in that one exhibit? I mean, I'm a little bit off topic here, Michael, but here it is. Miku is this one.
It contains personal information. Yeah, there was personal information probably. I mean, there's stuff you're not supposed to file and open documents. I mean, look at the defense's motion to correct error, the Reese Davis exhibit, for instance, and the FBI subject information sheet for Brad Weber had a whole bunch of stuff redacted out.
Mm-hmm. True. Well, then, yeah, couldn't he have just filed it without redacting it? But filed it under seal. If he was so worried about
it's not filing confidentially. He could have, and what he could have done is a redacted version, and then filed a confidential version.
Yeah, that feels like what he should have done probably. But then again, it is Nick McClellan we're talking about, so who knows? Who knows why he does the things he does? Not me.
Well, the defense didn't do that. The defense didn't do that with the Reese Davis tip or the FBI subject information sheet, Weber. So I don't know. It seemed like, if you leave in, I mean, yes, technically that would probably be the correct way to do it. But the other thing is, if the other side is claiming you're somehow misrepresenting something because of the way you redacted something, then they have the original, or they can demand the original. I don't know. I think both sides did the redactions, basically not wanting to burden the record. It's an extra step. It's the full thing probably doesn't make a difference.
Makes sense. Real quick, this has been in high demand.
Yeah, there he is. Brad Weber just left. Brad Weber, how'd it go? Brad Weber, did you do it? Brad Weber, did you do it?
What you tell me?
Michael, we don't have one of you, but it's only a matter of time before you are crank clipped.
Before I'm great.
Before you get crank clipped.
Yeah, I wish people
happen.
would get off, Brad. I
know.
I suppose anything's possible in this case, but going the Brad Weber stuff. I mean, it just, from the stuff I've seen, there's really no reasonable possibility he had anything to do with it.
Wrong.
I don't think he did either, Michael. I just think that.
I am sure that some Kathy Shank will come along in a couple of years, going through my files and see he was cleared, but then
right. And then she'll change it to not. Well, then he'll become a POI maybe in another case or at another time. I think Nick knew that he arrived home later. I have said about 1,000 times I've never believed in Brad Weber's story. I've said this before, Michael. I'll say it again. It's a bit crass, so plug your ears if you're not in the mood. Delphi is it's like you swing a dick, you hit a bridge guy, you hit a viable suspect. They're everywhere. They're not very far. It's like there's so many viable POIs and suspicious characters in this case that I don't even know how they would go about excluding people. It's almost like they realized that and they were like, there's no way in hell we're going to be able to. There's too many weirdos here, and they just stopped trying to exclude anybody. That's kind of how it feels.
Well, I mean, just on what we know Weber got home long after the bridge guy video. And the other thing we know, and it's not from Weber, is we know he had a girlfriend over at his parents' place that night who heard a thump. So he's not out in the middle of the night either, doing really awful things. So I just don't know how people, in light of those two things, I don't know how people think he was possibly involved. And I'm always, as I put in an email today to somebody saying I really didn't think there was much to a case. Everything is subject to correction by reality.
Mm-hmm. I like that. So, so this clip, it's a fan favorite, and apparently Lana was asking Brad Weber, why'd you do it? Meaning, why'd you change your story, Brad? Not why did you commit the crime? Why'd you do it, Brad? Why'd you change your story? We don't know.
Well, the story he changed, I'm sorry, the story he changed was what he told Pohl. And I think he was lying when he talked to Pohl because he didn't want to put himself anywhere near the crime.
Yeah, he wanted to be far
His
away.
place has been searched already. Yeah. I think the poll the poll interview was the lie about the ATMs.
Mm-hmm.
Look, we've got the white van coming home on video.
Yeah.
We've got his phone pinging at 2:50. He's not out doing ATMs. Unless that white van is not his, in which case, you know, yeah, maybe he was out doing ATMs and somebody else in a white van drove in. But again, that was too late.
Right.
To have been involved in the abduction. That was, could have been somebody driving down, but that's already, more than 10 minutes after the phone stops moving. And yeah, I don't know. There's a lot about this that's a conundrum.
There's a lot about this that's a conundrum. I wonder, and here's my question, Michael, because we know there is no shortage of folks in this Delphi saga from the beginning, involved, not involved, all across the board. There's no shortage of people who have lied or changed their stories or not been truthful. My question is, why? Why are there so many liars, and why are there so many lies? I don't get it. In this case, it feels like there's just so many people who have not been truthful.
Well, I think it starts with, what has always been, and it doesn't have to be right, but my thought has been that there were 1 to 3 people who needed to cover something up, and it started there, and then you have the higher level scrambling, not to reinforce the reason, not to reinforce the cover up by the 1 to 3 people, but to push the law enforcement narrative that was finally chosen.
Yeah, that makes sense. And then they could kind of justify that, in their own minds. I imagine they're doing this for whatever reason, and it's like the truth should probably be the narrative, but regardless. There's also the other reason, I think, because they all have something to hide in their own lives, or many people have things they don't want to come out in their own lives, whether it's related to the murders or just like other things. I do believe, there are multiple kind of a convalescence of reasons that people lie, and not all of those reasons, and probably most of those reasons, have nothing to do with because they committed the murders. But it would be a lot easier if they just would stop lying.
Well, to me, the biggest lie there were certainly some lies at trial, but the biggest lie at trial, and I've said this before, but the biggest lie at trial, and I really don't know how, I really don't know how Cicero did it. To say the sticks, he's a crime reconstruction expert. To say that those sticks were put there to cover the bodies, it's just preposterous. He can't possibly believe that.
I don't think he does believe it. Just like he could not give a explanation or reason as to why Abby's hands were clean, completely clean. He said, that is very unusual. I have no explanation for that. So like, instead of,
well, but there I think he's telling the, I just think he's telling the truth there. He has no explanation for it.
Right.
Kind of like Cecil saying he has no explanation for why the Snapchat picture of Abby on the bridge isn't on the phone.
Right.
That's a little different from being absolutely dishonest about the sticks.
Right. Yeah. And this too, I just don't, an F or an L on the tree, that is not a handprint. And we've all seen, at the very least, I think everybody has seen the tree, the F tree or the upside down L tree, which again, an upside down L is just 90% of an F. So it's like there's just a lot of purposeful. Yeah, I don't get it. Like, there's no way that he really believes that that's a handprint. There's no way that he really believes that those sticks, 3% of the girl's bodies being covered, is with the purpose of concealment. It's just, who are you serving? Like, why are you doing this? That's what I want to know. Like, why are you doing this and behaving this way? I mean, I don't think we'll get an answer ever, but I don't believe that they actually believe the stuff they say most of the time.
Well, yeah. I don't know. I mean, I listened to the interviews by the Tweedles, and these people have longish careers, and Cecil. I mean, listen to Bob Motta's account of Cecil. He's sort of earnest and methodical, and I don't think these people go out and regularly lie, and they may not have to, right? In many circumstances, but the lie about the sticks, I mean, that has to have been coached. I mean, if he's a professional, as a professional, he really. I mean, it's almost like if you put me on a witness stand and asked me to say, you put me on the witness stand and to say something that the law is not, because that's how, like, the person I'm testifying for wins. I don't know. I mean, am I going to say that under oath just to? It's like, I've got a job, and if I say that, what does that do to my credibility? I don't know.
Yeah. 19 minutes, clean hands, none of it makes any sense. And I think this could be it too. A lot of people are saying they were coached. I think that is true. And Ayantu and Post Punk Mama said they're doing the go along to get along.
Yeah. But it's an extreme. So, there are various versions of go along to get along. I mean, there's the plausible go along to get along, but this is just, the sticks were there to cover, trying to hide them. I mean, that's preposterous.
I agree with you.
I mean, one of the sticks was sawn off.
Yeah, with like a handheld electric saw or something.
Well, I don't know if we know by what, but I mean,
Well,
there
right.
are little saws that you can fold up in your pocket.
Mm-hmm.
And I don't know by what, or we don't know where. I mean, like, did anybody bother looking for a sawn off branch anywhere around? Did it come from there? Now, there were sawn off branches in Brad Weber's garage, but at least one. I don't think that means anything, but it's like, did anybody look around the crime scene for a branch that had been sawn off?
They didn't even take the sticks, Michael. They didn't even take the sticks. Doofy Dan Doolin went back to the crime scene like the 16th or 17th, and the sticks were still there, and they didn't collect the sticks for another week or two. So, like, how are they going to know? Do we even know when you can't? They've ruined all of their chances of knowing if that is like a freshly cut branch, if that's a not for like. They're just foolish. It's like, why didn't they do? Because then they're like, oh, we had the FBI helping us early on. There was not a single FBI or state crime scene person there that could have been like, hey, guys, maybe we should take the bloody sticks. Like, how did so many things go so wrong in one case? How were there so many fuck ups despite so many cooks in the kitchen? I just don't understand it.
Well, one question I have is whether, the FBI gave the Unified Cabal the Orion database, and I'm guessing that so it was the Unified Cabal operating that, not the FBI. And I'm really curious, FBI, did that search warrant on Ron Logan's house. I'm really curious whether the Reese Davis tip from May 2017 or the results of his interview in June of 2017 were given to the FBI.
I mean, I personally highly doubt it. I doubt that they would have given that to the FBI. This is kind of my white whale, but the FBI did not participate. They weren't the executors of the actual search of Ron Logan's property, despite being the authors of the search warrant. It's like they kept the FBI at arm's lengths at every turn, and then perhaps Reese talked to an FBI agent, and that. So do we know for sure who spoke to Reese in May 2017 and how many times he was spoken to? Because Reese Davis does reference an agent in one of his letters, either his conversation with Baldwin or his letters with Baldwin. And one of the questions we had was like, that the task force had that Reese Davis and Mike Peasley were their two kind of FBI guys that they had from beginning to end. But like, they're not really like FBI guys. They're like ISP guys that are like FBI task force. Anyway, all of that to say, I do feel like they had an FBI guy or two that like stayed on the case, but I don't feel like they necessarily conducted themselves or behaved them, in a way that was consistent with how. I don't think it helps very much. I don't think that they were very much help to the investigation is my point. So like, I don't know. I want to know more about why the FBI didn't do more or wasn't allowed to do more. I want to know more about why the FBI was kicked off and when. I have a lot of questions about that. I don't know who has the answers.
I mean, my question. So, my understanding, Reese did use that word agent and one of the communications. I don't remember which one. But as far as we know so far, the only interview was by this ISP guy, Hansard, in June. So Reese's girlfriend sends in the tip with the information from Reese. And May 15th, I think it is, of 2017. And then it takes them 6 weeks, June 21st, 2017, that Reese is interviewed by this Indiana State trooper. And he's the guy whose handwriting is even worse than Reese's.
It actually made me angry reading his notes. They were so sloppy. It made me really angry. Like, it's like the most important interview that you do and you can't even make sure your notes are legible. Like, it just felt very lazy and unconcerned. That's just my opinion.
I don't know if it was lazy. It's just maybe the way the guy.
Yeah.
But that's the only interview I know about. I'm not, why Reese used the word agent. But my question is whether, so the FBI, is really into Logan being involved, and what would if they weren't shown the tip and the result of the later interview with Reese, what would have been its reaction if they had been?
Right.
Almost certainly you got to go get this guy and arrest him.
Right.
I mean, there's a lot more. I mean, just in the 2017 interview stuff, there is more than they ever had on Rick Allen.
Yeah. Oh, this is a really good question. And I saw Judge Jessica and Post Punk and someone else raised this question before, and now Blind Hog is saying the fact that Nick McClelland fed the box cutter theory to the medical examiner, or like put that forth to somebody, because he got Reese's letters that mentions a box cutter maybe, and he knew that the defense had gotten wind of those letters too. So they were like, oh shit, the defense is going to talk about a box cutter. We need them to assign box cutter to Rick. I don't know if I'm explaining that right, but it certainly feels like the timing of the box cutter appearing, the confession, and the timing of the letters, and the timing of the medical examiner changing his story, they're all just very, very in line with the pattern of behavior of the state in this case, to just like reactive changing of their story and their theory based on what they think the defense is going to do.
Except that it's also really interesting that they seem to have gone to the trouble of priming core on the box cutter thing, but then they didn't use it, and McClelland didn't use it as a detail only the killer would know, at least not from anything I heard at trial. Now, if he did, then, someone can correct me, but I think he only used the van. He didn't use the box cutter. And why would you prime core with the box cutter? I guess it makes it more, I guess the box cutter also makes it more believable that, Rick Allen did it alone, because otherwise, he would have had a whole tool chest. Gun, 2 knives, one with a serrated edge and the other with a straight edge, and a saw. And I don't know about you, but I didn't see any tool. I didn't see Bridge Guy was carrying a tool chest.
Right. Somebody asked, so wait, do we know? Okay, so Catastrophe is one of our Delphi Encyclopedia librarians. She says medical examiner was deposed by the defense in February 2024. Isn't February 2024 when Baldwin first got up with Reese Davis, or was that March?
I think it was March.
Okay, interesting. Ask Osbrick about white car at 208. Old Google Maps shows a white car in Tobe's driveway by Packers. Tina Rodell messaged him at 2 p.m. about something going down at the Monon High Bridge. Is it possible he drove there? I have no idea what any of that means, Michael. I hope you do.
No clue. There was no. So there was, and the video's gone. But I thought there was a video that somebody had up. It was extremely boring video, but there was a white van parked on 100 out by Packers from 150 to 340, I think it was. And it didn't go anywhere. And the video didn't have the van arriving. So I don't know when it got there, but and it just sits there for an hour and 50 minutes and then drives away. Nobody ever gets out of it. Nobody gets into it. Nobody gets out to take a pee. Now maybe it's a guy and he's got a cup. Who knows? It's just extremely strange. And when I say parked on 100, it's a skinny little road. And it's actually parked in the road in the video. It's not like it's off on the grass. So this is a security cam video from an elevated position on the meatpacking plant. And so yeah, and there was a moment when I was watching that at about 3:25. About 3:25, I think it is. Some sort of, I think it's like a dark Jeep drives by, and I'm sitting there going, having watched this incredibly boring thing, I admittedly on speed it up, but this black Jeep drives by headed towards 421, and I'm going, oh please follow it. And it doesn't. It just sits there for another 10 or 15 minutes and then drives away. So I mean, it wasn't like it was connected with something going on there. So I know nothing about Tina Rodell and a message saying something's going on over at the Monon High Bridge. First I've heard of it. Would love to know more about it.
So if people have information, Michael, that they want to get to the attorneys or the whomsoever, how should they get that information to them?
I would send an email to Delphi. Yeah, I would send an email to Delphi Tip Mail, all one word, at gmail.com.
At gmail.com. Delphi Tip Mail at gmail.com.
Yeah.
If you have a Delphi tip or more information that you think would be good to get into the hands of someone else, an attorney on Rick's case or helping Rick's case or appellate whomsoever, Delphi Tip Mail at gmail.com. Sounds good. Just send the tip. Just the tip. Thank you, Grace Space. Yeah. Galapoo is the one who heard this. Kat says Galapoo is at the very least the witness to the two box cutter. Galapoo is the witness to the two box cutter confessions, is what Catastrophe says. So
okay.
No, I'm just reading this. So important. He didn't bother writing it down or telling anyone. Yeah, it's so weird that we hear about all these confessions that Rick made in Westville. The most specific ones, there doesn't seem to be any record of them.
Well, my understanding of the Walla Van confession is that she doesn't have the original notes anymore, but she did put it into a computer report. My understanding is that in the business she's in and sort of the business you're in, Angela, that you might write the computer reports, but you don't destroy the original notes.
No, you would do one. You would do one or the other. Generally, your notes would be, you're not writing handwritten notes, period. But whatever notes you take, as the soonest that you're noting anything, those are your notes. You don't come back to them later and summarize them, or that just doesn't make any sense. You would put your notes.
My understanding was
yeah.
My understanding was Walla was doing handwritten notes.
I imagine that she probably was, and that's insane. I don't know why she would be doing that, but regardless, then those are her notes. You know what I'm saying? Then those are your notes. Then you scan them into whatever or whatever. You don't. That's just bizarre to me. Honestly, I think Walla's full of shit. I think that Walla is full of shit. Whatever she did write down or whatever, sure, maybe she destroyed her notes, and maybe that's their policy, even though it's an insane policy. But the fact that I believe that Walla retroactively did her notes, whatever that means. Maybe she was in the habit of waiting weeks and weeks to save her, to do her clinical notes after a session, which is insane. Regardless, her notes are not, I think that they're made up out of whole cloth. That's quite an allegation to launch, but as somebody who has to take clinical notes quite a lot, I think she's full of shit. I think that she lied. And that's a scary thought, but I think that Walla is a liar. It's bad. I don't know what recourse there is for a psychologist in a...
Well, that's actually, the funny thing is, of course, that's going to be hard to prove, because you can't put Rick on the stand to say I never said any such thing, because then they'll cross-examine. Oh, but you were crazy because you were in solitary. So how could you?
Well, he has said that.
They discredit him.
Yeah, he said, I don't remember
saying any of that. He has said what?
Rick Allen has said that he does not remember saying any of these confessions. He has no memory of any of it. And they even say, you know, and this has come out during the hearings, during the trial, and in interviews afterwards. So I'm not saying anything that's not out there. Like, he does not remember the period of time when they were drugging him with Haldol and he was psychotic. He has no memory of it. So he's not even a witness to his own alleged statements. So that to me is a really concerning. I don't see how any of that could be admissible, but here we are. There's a lot of things that shouldn't have been admissible in this case. But like, what do you do about that? And in what universe are the clinical notes of a psychologist admissible at a trial? I understand the Indiana rule, the criminal rule with the homicide exception. That's insane. There's something wrong with Indiana that's an exception. That's insane. I can't even talk about Walla. I can't talk about Walla. It gets me so triggered because she's so dangerous. She and Dr. Martin are so dangerous, and I can't even go there because what I think needs to be done about it, it's not any of my business. So it doesn't matter, but it's fucked.
Well, Dr. Martin has strange degrees from, I don't know, the Bahamas or wherever.
He's from another planet. He's from Crazy World. It's
Dr. Martin, it's hard to even call him doctor.
I know. Fiend was there for Dr. Martin's, at least one of, I think that Fiend was actually there for the state's rebuttal at the very end. And he actually witnessed the Dr. Martin 180 when Nick brought Dr. Martin back and tried to ask him about, oh, so you're saying Rick was totally lucid and doing great when you saw him on this day. And then Brad comes in with a video recording of Rick that same day, a couple hours later, and he's catatonic. And Dr. Martin literally has to change his opinion. He's like, no, I don't think that he's, I do believe that he's like psychotic or whatever he said. Like, that was right at the end of trial.
Yeah, and I don't think Brad used that in closing.
Yeah, well, DB says, hey, can you ask Professor Osbrook how he feels about Clarence Thomas's record in general and more specifically his dissent in Glossip? No is a fine answer.
Glossip is a capital case. I don't think that I think it well may not have come out the same way if it hadn't been a capital case. The mistake about whether the guy was on lithium or not, I mean, I don't really know about the really the fine details of the factual record in the case. I will say that Clarence Thomas's jurisdictional protestations are pretty weird.
Pretty weird. Okay, we'll take it. His jurisdictional what? I didn't hear that next word.
His jurisdictional protestations. He was, he was, if I recall correctly, he was trying to claim the court really didn't have jurisdiction to consider the case. And the guy's, you know, he's a loose cannon. I mean, you know, he can be on occasion, and one particular area that I can think of, defense friendly, and that's kind of the Blakely v. Prendy and Blakely v. Washington stuff. But you know, basically, he's he's been on the court forever now, but he's essentially a crackpot. You know, theory that
not
the
a crankpot.
No, not a crankpot. No. Yeah, has this theory that the that the Constitution incorporates the Declaration of Independence. Like, really? That's a little odd. Yeah, I don't know. I mean, you know, who'd have thought that a justice would arrive in the form of Sam Alito to almost make Thomas look good.
Like you think we've hit the bottom, Michael, and we just keep digging. We just keep digging. I wonder if Walla would talk about how fucked up Idaho is.
Well, look, you know, the confession to Walla is the keystone of because of the white van. But that said, there were recordings. Again, I wasn't at the trial. But by all accounts, there were at least a couple of recordings. One of maybe a confession to Kathy, and another confession to his mother, where he at least sounded relatively lucid. I don't put much credence in them. I'd have been saying anything to get out of there. And there is that really weird one where apparently the recording continues, and he says something like, after his wife or mother, I don't remember which it was, but after whichever one it was had hung up, he's heard to say something like, okay, as if he was being prompted to say those things.
Yeah, like, all done. I did it. All done. Is that yeah, okay. I have a lot of my own suspicions and worries about what was going on and how they were communicating with Rick. So we know they were banging on his door. You know, child killers don't sleep here, keeping him up, screaming at him all hours of the day and night. We know that he had, at the very least, Dr. Walla going to check on him every day, which is not standard and not normal. And I believe that there was a period of time where Rick refused. He did not want to make calls from his tablet. And he said multiple times that he believed that they were fucking with his tablet. And I would not be surprised, Michael, this is my own crankpot conspiracy theory. I believe they were fucking with him and communicating with him through his tablet. If he's psychotic, you really think people are not going to be... And also, you got Harshman hiding out in the rafters like a creepy weirdo for 700 hours. Like, you really think, this is, you know, not you, but does one really think it's ludicrous to assume that they're fucking with him psychologically and talking to him like through his tablet and through the walls? And like, he was psychotic. So he would say, I don't know if it's God or I don't know if it's me or if I'm crazy. Like, they 100% were fucking with him in every single possible way. And what sucks about that is it's impossible to prove and we'll never know. That's what I think.
Well, it's not impossible to prove, and that's one reason I have some, you know, I'm hoping the civil rights lawyers are going to get on it and get a little federal discovery, and we may not be able to prove all of it, but I'm willing to bet that if that happens, the discovery will produce fairly shocking details we do not know yet.
I'm certain that they would. If there is federal discovery that comes forth and that is pursued and that is allowed and all of that, I have no doubt that there would be some very, very disturbing revelations, even more disturbing than what we already know. There's a reason that everybody who touched Richard Allen and his case while he was in Westville, there's a reason that they're all gone. None of them are there anymore. Their COs have left, Walla's left, Marmon's left, the warden's left. That's not normal, speaking of normal.
Well, I think Rick Allen, I mean, you know, subject again to correction by reality, but I think Rick Allen was treated in a way that no pretrial detainee in the history of the state's ever been treated.
Right. I mean, I would argue even more than that, but I mean, that's sufficient in the state. No pretrial detainees ever been treated like that ever in the history of Indiana. That in itself should make people ask more questions than they ask. They're just so complacent, or they're just so willing to accept whatever the answers that they've been given that aren't really answers. I mean, I just would never be satisfied if I were a local or family member of somebody who was directly impacted by the murders directly. I would never be satisfied with what has come out and what the conclusion has been. I don't get it.
Yeah, I mean, I have reasons. I have, invented reasons that, might explain it, but that is the damage that might be done if it really came out what happened, would be worse.
Yeah. This is a good question. Do we know that the defense audited the medical record software before the third hearing and found that she accessed KK's records? Were they able to audit the software to see who all has looked at Rick Allen's chart? So that's a great question. And that's something that I think, Michael, I've ranted about to you at least before, of like, if I'm in an EMR system, whatever it is, any kind of medical system, probably any kind of DOC system, but certainly medical records, if I open a chart, there's a record of that, right? If I type something in and search somebody's name and they're not my patient, that can be traced back, right? Everything that you do, there's a footprint in an EMR system. So do they know who accessed what and when? And like, that would be really important. And I'm going to guess no, that they never did anything of the sort, but that feels really important.
Yeah, no idea what they looked at. Don't know much about the mental health records.
Yeah. It's bad.
Well,
Anything
I mean, the low point.
Oh, go ahead.
Yeah, I mean, I think the real low point on about this before I get off is, Gull accusing Rick's lawyers of lying when they were telling her about the conditions in which he was being kept.
Yeah, I know. And for her not only to say that they were lying, but to say that he's being treated way better than everybody else is, like, indefensible to me. Because there was more than enough.
Yeah, go ahead.
No, there was just more than enough evidence at that point, because it's just DOC's word against Brad and Andy's, and besides, we still never got an answer as to what the heck happened with Baston. Who interrupted his transport to be a witness that day? Gull says it wasn't her.
That was Gull. No, we do know that was Gull.
And yet, it's like, what is her deal? What is her motive? Because that was back in June 2023. She literally prevented their witness from coming and then said that they were lying. But she's the one that prevented their witness from coming and giving witness testimony. Like, that goes beyond just being a lazy or incompetent or bad judge. Like, that goes way beyond that.
Well, I think Andrea actually almost as much as said that Gull's a monster.
Yeah, she has. I actually think that's a fair assessment of her. They changed his religion. I don't know. What did they change his religion to? I don't remember. You're probably right, though. This case makes me lose my religion. Honestly, I think she gets a kick out of making people suffer. Oh, Lord, I wish that I could have screamed when she said he's treated better than most, whatever. Yeah, there's a lot of people in here who agree with the monster comment, Michael. Ask Michael
Well,
what
on these
his...
happy notes.
Yeah, go ahead.
Go ahead.
So Cleveland
No,
says,
no.
ask Michael what the Shakespeare insulator says about all of this. Or the Shakespeare insulter, sorry.
The Shakespeare insulter. It's I actually asked the Shakespeare insulter about all this, and I got the answer back. Sorry, above my pay grade.
Above my pay grade. Well, we'll just have to never know, I guess.
So on a happy note of how Rick was treated in prison, I think unless anybody's got any more questions about Glossip, I mean, I think Glossip's pretty straightforward, frankly. I think I will bid you all farewell, and I really appreciate the opportunity.
Well, Michael, I appreciate you coming on and talking to us about Glossip. As always, we always love a Professor Michael Osbrook head habeas crank. We always love an appearance. And yeah, Fiend says I made you. I'm sorry, Michael. We ended on a sad note. If I depressed you for the evening.
Hey, at least you all are doing what some other folks on another live were doing the other day and calling me a nerd.
You are a nerd, but so is everybody here. Then that's okay. I mean, there's so many worse things that I could think of to call them, but I won't. Judge Jessica says, "Thank you, YouTuber Michael Osbrook." Thank you.
Well, as I said, come for the clicks, stay for the procedural defaults.
Come for the clicks, stay for the procedural defaults. Hashtag Krebin Nerd. Thank you so much, Michael.
Okay. See y'all. Thanks.
Bye, Michael. I did that, says Andy. He comes for the Todd clicks. How do we get clicks for Michael on his video? Andrea and Andy are the ones that's... Oh, you're the ones that said it. You're calling Michael a nerd? But nerds are good. We were going to reclaim the word nerd, much like we have for the word queer and the word crank. Next, we're going to reclaim nerd. I like it. Let's do a Russian bot. Blessings to Michael. Thank you, Michael. He's a nerd. Nerds are smart. Nerd is definitely a term of endearment. Okay, I get it now. Hottest nerds in Krebin, baby. How do we get clicks from Michael on his YouTube channel? So that's all I wanted to go over. I actually planned to do something else later. So I might not. I might. But I do think I'm going to end the live now and perhaps come back later. Michael has 222 subs. Wow. He is in it for the clicks. Yeah, I might come back later. Hey, is anybody interested in Menendez? Yes or no? 1 if yes, 2 if no. 1 for yes, 2 for no. Have a return. Please do. That's bullshit, Ange. Stay on. I mean, I could stay on, but I have to take Booney out and do a snack, so it'll be like 20 minutes. 2 for no, 1 for yes, 1 for yes. Latest Gatas. When I was in school 20 years ago, if I was called a nerd, my reply was yes, and you're just jealous. 1 for yes, 1 for yes, 1 for yes. So what if I do this? May, you could probably make me interested. Okay. I bet I could be. I bet I could. Because we're going to do an Ann Burgess, actually. Have a do. 1.34 out of 4. I was always told the nerds would be rich one day. I'm going to take the Booney out. I'm going to eat something quick, and I'll come back probably around 8:30, maybe 9. Look for live. Turn your notifications on. Meister at 8. Oh, Michael. Okay. Well, I don't want to get in the way of... I'm going to clear the floor and keep some space for Frank Meister. Did you hear that? Did you hear that? Oh, my goodness. I have a monster right here. I don't think you can see him. And if I try and move my camera, I will knock everything off my desk. But I'll be back in like an hour or so, everybody. I appreciate you. And thank you, Michael. And free Rick Allen. Can you send us to Meister? I don't know how to do that. Wouldn't that be funny though? Was that a grumble? Yeah. Come here. Come here. Can you come up here? He's a chunker. I don't even want to like pick him up. They're demanding you. Come here. Look at this guy. He's just staring at me for snacks. An android. Can you imagine? Say hi. Oh, there he is. Hi. This is Boone. Just chilling. Okay. So we're going to be back. And I have a monster here. I thought Gull was changed to the floor. Never mind. Let me see a loose cardboard. Okay. All right. Goodbye. I don't know how to send you to Meister. You'll find him on your own. And if you go, tell him that I sent you. Goodbye.